An FIR, First Information Report, is a very important written document made by the police when being reported a cognizable offense. A cognizable offense is an offense which allows the police to arrest someone without a warrant. The main purpose of an FIR is to set the law in motion. However, it is not in itself a substantive piece of evidence, nor is it an exhaustive document. It can be used if there is a conflict of statements or evidence during a trial. An FIR does not mean that the person accused of committing the offense is officially guilty. It only initiates trial proceedings and is the first step in the criminal justice system process. Lodging the FIR. The process of lodging an FIR is provided in Section 154 of the CRPC. According to Section 154, every piece of information relating to the commission of a cognizable offense must be reduced to writing and read out to and signed by the informant. In cases where information is given by a woman aggrieved by Sections 336B, 354A, 376, or 509 of the Pakistan Penal Code, the FIR must be recorded in the presence of a female officer or a female family member or any other person with the consent of the complainant, as the case may be. If the complainant is distressed, such information may also be recorded at her residence or at a convenient place of her choice. Investigation. According to Rule 24.1, the Police Rules 1934, any information relating to an offense collected under Section 154 CRPC must be recorded in writing. Under Section 157 CRPC, where the information raises a reasonable suspicion of the commission of a cognizable offense within the jurisdiction of the police officer to whom it is given, the officer in charge must send a report of the same to a magistrate and proceed either in person or by deputing one of his officers to investigate the matter in question. The officer in charge may decide not to proceed with an investigation where A. Information is given against a person by name and the case does not appear to be serious in nature, or B. The officer sees no sufficient grounds for investigation. Provided that the officer must record his reasons for not proceeding in writing and, in case of Proviso B, must also inform the informant that he will not be proceeding with the investigation. Can the suspect be arrested? Under Section 54 CRPC, where there is a reasonable suspicion that a person has been involved in a cognizable offense or against whom a reasonable complaint has been made or credible information has been received, any police officer may arrest said person without an order from a magistrate and without a warrant. However, such arrest cannot be effected on the basis of mere surmise. Who can lodge an FIR? An aggrieved person who has been affected or is an eyewitness can lodge an FIR. Contents of the FIR. The complainant is to accurately mention the name of the police station, time of the incident, time of information, short story of the incident, informant name, and the name of the suspected offender. Facts should not be distorted or false. Under Section 211 of the Pakistan Penal Code, instituting criminal proceedings or causing criminal proceedings to be instituted against a person with intent to cause injury, knowing that there is no lawful ground for such proceeding, is a punishable offense. Alternative remedies. In case of non-registration of an FIR, the complainant may file an application under Section 22A, 22B, before a magistrate to issue a direction to concerned police authorities regarding non-registration of a criminal case, or neglect, failure, or excess committed by a police authority in relation to its function and duties.